Good morning. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on the unconstitutionality of President Obama's executive actions on immigration, and I'll begin by recognizing myself for an opening statement. Last November, President Obama announced one of the biggest constitutional power grabs ever by a president. He declared unilaterally that, by his own estimation, almost 5 million unlawful aliens would be free from the legal consequences of their lawless actions. Not only that, by granting them deferred action, he would bestow upon them benefits such as legal presence, work authorization, and access to the Social Security Trust Fund and the Earned Income Tax Credit. President Obama took these actions despite having stated over 20 times in the past that he didn't have the constitutional power to take such steps on his own. As the Washington Post's own fact-checker concluded, apparently he's changed his mind. The Constitution is clear. It is Congress's duty to write our nation's laws. Yet President Obama admitted that, "I just took an action to change the law," quote unquote. The Constitution is also clear that once laws are enacted, it is the President's responsibility to enforce them. The Constitution requires the President to take care that the laws be faithfully executed. Yet the very integrity of our immigration laws is now in question. 26 states believe that President Obama's actions would cause them irreparable harm. They challenged his grant of deferred action in federal district court in Texas. The court agreed with the states and has granted a temporary injunction halting for the moment the administration's plans. The court stated that the administration is, quote, "not just rewriting the laws, it is creating them from scratch," end quote. President Obama has justified his actions under the guise of prosecutorial discretion. Law enforcement agencies do have the inherent power to exercise prosecutorial discretion, the authority as to whether to enforce or not enforce the law against particular individuals. However, telling entire classes of millions of unlawful aliens that they face no possibility of being removed is not prosecutorial discretion. It is simply an abdication of the executive branch's responsibility to enforce the laws. The President relies on a memo prepared by his Justice Department's Office of Legal Counsel to attempt to justify his actions as constitutional. But that very memo finds that, quote, "immigration officials' discretion in enforcing the laws is not unlimited. Limits on enforcement discretion are both implicit in and fundamental to the Constitution's allocation of governmental powers between the two political branches," end quote. The memo admits that the executive cannot, under the guise of exercising enforcement discretion, attempt to effectively rewrite the laws to match its policy preferences. And the memo quotes the Supreme Court's Heckler versus Cheney decision in stating that the executive branch cannot, quote, "consciously and expressly adopt a general policy that is so extreme as to amount to an abdication of its statutory responsibilities," end quote. The memo, in fact, is an indictment of President Obama's actions. The federal court in Texas agrees. It found that the grant of deferred action, quote, "does not simply constitute inadequate enforcement. The government here is doing nothing to enforce the removal laws against a class of millions of individuals. The grant of deferred action does not represent mere inadequacy. It is complete abdication," end quote. And the court points out that President Obama's actions go beyond even utter non-enforcement. He is, in fact, granting affirmative benefits to these aliens, as I described earlier. In absolutely no way can President Obama's actions be considered a justifiable use of the administration's powers of prosecutorial discretion. They are a clear violation of his constitutional responsibility to faithfully execute the laws. The President also mistakenly claims that his actions are nothing new. It is true that previous presidents of both parties have provided immigration relief to groups of aliens. However, most often the actions were based on emergencies in foreign countries, thereby relying upon the broad constitutional power given to a president to conduct foreign affairs. For example, Chinese students were protected from deportation after the Tiananmen Square massacre of 1989. What about President George H.W. Bush's family fairness policy, which the White House cites to justify its power grab? This grant of voluntary departure was in fact authorized by the Immigration and Naturalization Act as it existed at the time. Without any crisis in a foreign country to justify his actions, and in granting deferred action without any statutory authorization, President Obama has clearly exceeded his constitutional authority. No administration has so abused and misused the power of prosecutorial discretion as has the Obama administration. By assuming legislative power, the Obama administration is driving full speed ahead to a constitutional crisis, tilting the scales of our three-branch government in his favor and threatening to unravel our system of checks and balances. This administration has entered the realm of rewriting the laws when it can't convince Congress to change them. The House of Representatives has taken decisive action this year to protect the Constitution. We have passed a Department of Homeland Security appropriations bill that would defund a series of unconstitutional actions of the Obama administration, including this grant of deferred action. Tragically, the House-passed bill is being filibustered in the Senate, even as appropriated funds for the department are set to run out at the end of the week. By not even allowing the bill to be debated, those senators who have chosen the path of filibuster and obstruction are threatening DHS's access to funds designed to keep Americans safe. They are also denying the American people a fair debate on this vital issue of whether Congress needs to take action to protect all our constitutional liberties. We can only hope that they will relent in time. I look forward to today's hearing and the testimony of our witnesses, and it's now my pleasure. Chair thanks the gentleman, and it's now my pleasure to recognize the chairman of the Judiciary Subcommittee on Immigration and Border Security, the gentleman from South Carolina, Mr. Gowdy, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, the thread that holds the tapestry of our country together is respect for and adherence to the rule of law. The law is the greatest unifying and the greatest equalizing force that we have in our culture. The law is what makes the richest person drive the precise same speed limit as the poorest person. The law is what makes the richest person in this country pay his or her taxes on precisely the same day as the poorest person in this country. The law, Mr. Chairman, is symbolized by a blindfolded woman holding a set of scales and a sword. The law is both a shield and a sword, and it is the foundation upon which this republic stands. We think so highly of the law, Mr. Chairman, that in the oath of citizenship administered to those who pledge allegiance to this country, to their new country, it makes 6 different references to the law. So attempts to undermine the law via executive fiat, regardless of motivation, are detrimental to the foundation of a democracy. President Obama, after the November midterm elections, I hasten to add, announced one of the largest extra-constitutional acts ever by a chief executive. He declared unilaterally almost 5 million undocumented aliens would receive deferred action under some newfangled definition of prosecutorial discretion. Moreover, in addition to using prosecutorial discretion as a license to rewrite the law, he also conferred benefits on those same people. You may like the policy. You may wish the policy were the law. But one person does not make law in a republic. If you enjoy a single person making law, you should investigate living in another country. Because our framers did not give us, nor have generations of our fellow citizens fought and served and sacrificed for a single person to make law in a unilateral way. So removing consequences for breaking the law is one thing. Bestowing benefits such as work authorization and immigration benefits is another. The president himself recognized his own inability to do this, Mr. Chairman. More than 20 separate times he said he lacked the power to do what he ultimately did. In 2011, he said this, and I quote, "The notion that I can just suspend deportations through executive order, that's just not the case." He told us time and time again, Mr. Chairman, that he was not a king. His position may have changed, but the Constitution has not, and that document is clear, and it is time-tested, and it is true, and it says that Congress passes laws, and it is the responsibility of the chief executive to take care that those laws are faithfully enforced. The prosecutorial discretion. However, he's sitting down. Sir? A lot of conspiracies. That better? Is that better, Mr. Court Reporter? Let me see where I was. Oh, his position may have changed, but the Constitution has not. Prosecutorial discretion is real and constitutionally valid, Mr. Chairman, but it is not a synonym for anarchy. As U.S. District Court Judge Andrew Hanen wrote in his recent opinion, DHS does have discretion in the manner in which it chooses to fulfill the express will of Congress. It cannot, however, enact a program whereby it not only ignores the dictates of Congress, but actively moves to thwart them. The Constitution gives the President a lot of power, Mr. Chairman. He's the Commander-in-Chief. He nominates Supreme Court justices. He can veto legislation for any reason or no reason. He can fail to defend the constitutionality of a law. He has the power of pardon. He has a lot of power, Mr. Chairman. But what he cannot do is make law by himself. That is the responsibility of the Congress. And if this president's unilateral extra-constitutional acts are not stopped, future presidents, you may rest assured, will expand that power of the executive branch, thereby threatening the constitutional equilibrium. And the argument that previous administrations have acted outside constitutional boundaries holds no merit with me. The fact that other people made mistakes is not a license for this executive to do the same thing. Mr. President, in conclusion, we live in a country where process matters. The end does not justify the means, no matter how good the intentions. When a police officer fails to check the right box on an application for a search warrant, the fruits of that search warrant are suppressed. When a police officer, even though he has the right suspect for the right crime, but he just fails to include one small part of those prophylactic Miranda warnings, what happens? The statement is suppressed, even though you have the right person, even though you have the right crime, because we view process over the end. And I'm going to say this, and then we'll finish. I'm going to say this to those who benefit from the president's policies. You may be willing to allow the end to justify the means in this case. You may well like the fact that the president has abused prosecutorial discretion and conferred benefits in an unprecedented way. You may benefit from the president's failure to enforce the law today, but I'll make you this promise. There will come a day where you will cry out for the enforcement of the law. There will come a day where you long for the law to be the foundation of this republic. So you be careful what you do with the law today, because if you weaken it today, you weaken it forever. With that, I would yield back.
Adam Paul Laxalt currently serves as Nevada's 33rd Attorney General and is the youngest Attorney General in the country. Prior to becoming Attorney General, he was in private practice in Las Vegas. Attorney General Laxalt served in Iraq at Forward Operating Base Camp Victory, where his team was in charge of more than 20,000 detainees. He has also served as a Special Assistant U.S. Attorney, as an Assistant Professor of Law in the Leadership Ethics and the Law Department at the U.S. Naval Academy, and as a Special Advisor to the Undersecretary of State for Arms Control and International Security. Attorney General Laxalt graduated magna cum laude from Georgetown University and also graduated from Georgetown University Law Center. Professor Josh Blackman is an assistant professor at the South Texas College of Law, specializing in constitutional law and the United States Supreme Court, and is the author of Unprecedented, the Constitutional Challenge to Obamacare, and over a dozen other articles about constitutional law. Professor Blackman clerked for the Honorable Danny J. Boggs of the U.S. Court of Appeals for the Sixth Circuit and for the Honorable Kim R. Gibson of the U.S. District Court for the Western District of Pennsylvania, and is also the founder and president of the Harlan Institute, which provides a stylized law school experience for high school classrooms, and the founder of the Internet's premier Supreme Court Fantasy League. Professor Blackman graduated magna cum laude from George Mason University Law School and magna cum laude from Penn State with a BS in Information Sciences and Technology. Professor Elizabeth Price Foley is a founding member and professor at Florida International University College of Law, where she teaches constitutional law. Prior to joining FIU, Professor Foley was a professor of law at Michigan State University College of Law and served as a law clerk to the Honorable Carolyn King of the United States Court of Appeals for the Fifth Circuit. Professor Foley is the author of multiple books on constitutional issues, including Liberty for All, Reclaiming Individual Privacy in a New Era of Public Morality, and presently serves on the editorial board of the Cato Supreme Court Review. Professor Foley graduated summa cum laude from the University of Tennessee College of Law and holds a BA in History from Emory University and an LLM from Harvard Law School. Professor Stephen H. Legomsky is the John S. Lehman University Professor at Washington University School of Law, focusing on U.S. comparative and international immigration, and is the founding director of the law school's Whitney R. Harris World Law Institute, a center for instruction and research in international and comparative law. He recently returned from a 2-year leave of absence, serving as Chief Counsel of U.S. Citizenship and Immigration Services. He is the co-author of Immigration and Refugee Law and Policy, which has been a required text at 176 law schools since its inception. Professor Legomsky graduated first in his class at the University of San Diego School of Law and clerked for the U.S. Court of Appeals for the Ninth Circuit. Your written statements will be entered into the record in their entirety, and I ask that you each summarize your testimony in 5 minutes or less. To help you stay within that time limit, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony, and when the light turns red, that's it. Your time is up. Please stop. Attorney General Laxalt, welcome. You may begin.
Mr. Chairman, Ranking Member Conyers, and members of the committee. My name is Adam Paul Laxalt, and I am the Attorney General of Nevada. On behalf of Nevada, I thank you for the opportunity to testify today about the state's lawsuit challenging President Obama's unilateral executive action granting deferred action to over 4 million people. I represent one of the 26 states that have sued the federal government. The state's lawsuit, while immigration is the substantive issue underlying the President's executive action, this lawsuit is not ultimately about immigration. Rather, it's about the President's attempt to change the law through unconstitutional executive action. Like most of us, I am the descendant of immigrants. My ancestors came here in search of a better life. My grandfather, Paul Laxalt, was the son of an immigrant sheep herder. He rose to become the governor of Nevada and a United States senator. In our nation's history, similar stories have been repeated over and over. They are what we have come to know as the American dream. However, it has never been true that in order to sympathize with the plight of immigrants or to believe in the American dream, one must reject our constitutional system. To borrow a phrase our president is fond of using, that is a false choice. In significant part, it is our commitment to the rule of law and to our Constitution that has drawn people to our shores across generations. Before taking unilateral action, the President said the following: "I am President, I am not the King. I cannot do these things just by myself. There's a limit to the discretion that I can show because I'm obliged to execute the law. I can't just make the laws up myself. We can't ignore the law. The fact of the matter is there are laws on the books that I have to enforce." These are a series of comments the President made before this action. Subsequently, on November 20th, 2014, after repeatedly acknowledging his duty to faithfully enforce the immigration laws passed by this body, and after emphasizing that he lacked the authority to unilaterally change those laws, President Obama directed his Secretary of Homeland Security to do just that and change the law. To quote the President himself, he said, "I just took an action to change the law," that on November 25th. In accord with earlier statements by the President, a coalition of states brought suit in federal court to enjoin the President's unilateral action. Since the lawsuit was originally filed, the number of states challenging the President's action has grown to a majority of the 50 states. The state's lawsuit focuses on 3 areas. First, the Constitution requires the President take care that the laws be faithfully executed. During the Korean War, President Truman, relying on the exigencies of war, unilaterally seized the nation's steel mills. President Truman justified unilateral action because Congress had refused to pass a statute authorizing his action. The Supreme Court held that Truman's actions were unconstitutional. Here, as Judge Hannon, the federal judge presiding over this case, has observed, no statute gives the Department of Homeland Security the discretion it is trying to exercise. Quite the contrary, the President's executive order not only ignores the dictates of Congress, but actively thwarts them. For the same reason that Truman's unilateral action in the Steele Caesar cases was held unconstitutional by the Supreme Court, we think President Obama's unilateral action here is unconstitutional. Second, federal statutory law, namely the Administrative Procedures Act, similarly requires that when an agency issues a substantive rule, it must be consistent with Congress's clear statutory commands. Under unambiguous federal statutory law, the Department of Homeland Security, here I quote Judge Hannon again, is tasked with the duty of removing illegal aliens. Congress has provided that it shall do this. The word shall certainly deprives the DHS of the right to do something that is clearly contrary to Congress's intent. The President's plan that millions of illegally present individuals be granted legal present, work authorization, eligibility for state and federal benefits cannot be squared with federal law, and therefore, we believe violates the Administrative Procedures Act. Third, when a federal agency changes the rules like the President has ordered here, the Administrative Procedure Act also requires that due process is followed. That is, the agency must give fair notice of the rule change and allow public comment before implementing the change. Everyone agrees that was not done here. So this is the third reason the states are arguing the President's action violates the law. As you all know, on February 16th, Judge Hannon found the states had standing and issued a preliminary injunction enjoining the implementation of the DAPA program. Now, why Nevada joined? As Nevada's chief law enforcement officer, Nevada law requires that I initiate or join litigation wherever necessary to protect and secure the interests of the state. This suit is not about immigration. It is not about politics. It is about the rule of law and our constitutional system. This lawsuit transcends policy differences and seeks to prevent legislation from being usurped by executive fiat. Nevada joined this lawsuit because upholding our constitutional process is more significant than any policy directive that any political party may be pushing at a particular time. Thank you again, Mr. Chairman, for allowing me to testify before this committee about this important issue.
Thank you, General Laxalt. Professor Blackman, welcome. I understand your parents are with us today. And they're
My dad's
welcome
in the
here
same
as well.
color tie, so you know who he is.
Excellent.
Thank you. Chairman Goodlatte, Ranking Member Conyers, and members of the Judiciary Committee. My name is Josh Blackman, and I'm a constitutional law professor at the South Texas College of Law in Houston, Texas. I am honored to have the opportunity to testify about why DAPA violates the Constitution and poses a severe threat to the separation of powers. In my brief time, I have 3 points. First, DAPA is an unprecedented exercise of presidential lawmaking power and is not consonant with previous exercises of deferred action. Second, DAPA violates the President's duty to take care that the laws are faithfully executed, as the executive must enforce the laws in good faith. Third, I will sound an alarm. Non-enforcement poses an encroaching threat to the separation of powers and the rule of law that Congress, not just the courts, must take steps to halt. So first, Congress has not acquiesced or given the President the authority to implement DAPA. The Justice Department's Office of Legal Counsel claimed that 4 previous instances of deferred action justify DAPA and its antecedent DACA through express or implicit congressional approval. These claims are demonstrably false. So first, in 1997, deferred action was granted for battered aliens under the Violence Against Women Act, VAWA, where a petition had already been approved, but a visa was not immediately available. Here, the deferred action served as a temporary bridge for those who would soon receive permanent status according to the laws of Congress. Second, in 2001, deferred action was granted for aliens who were already deemed to be bona fide under the Victims of Trafficking and Violence Protection Act. Here, too, the deferred action served as a bridge. Lawful status was immediately available on the other side of the deferral. Third, in 2005, deferred action was granted for foreign students who unfortunately lost their visas when Gulf Coast schools were closed following Hurricane Katrina. The deferred action bridged the gap and gave the students 4 months to enroll at another college or university in order to regain the status they previously held. Fourth, In 2009, deferred action was granted for aliens that were widowed by the untimely death of their citizen spouse before the minimum 2-year period. Deferred action was granted where visa petitions have been filed but not completely adjudicated by the government because of administrative delays. Again, a visa awaited shortly after deferral. Historically, deferred action acts as a temporary bridge from one status to another, where benefits were construed as immediately arising post-deferred action. In contrast with DAPA, deferred action serves not as a bridge, but as a tunnel to dig under and through the INA. There is no visa, the proverbial pot of gold, awaiting the other side of this deferred action rainbow. My second point is that DAPA violates the President's duty to take care that the laws be faithfully executed. Article 2 imposes a duty on the President unlike any other in the Constitution. He must, take care that the laws be faithfully executed. DAPA violates its duty for 3 reasons. First, with DACA, the blueprint for DAPA, the administration limited officers to turn discretion to a rubber stamp. This did not reallocate resources to further congressional policy, but rather was an effort to bypass it, and a transparent one at that. Second, because DAPA is not consistent with congressional policy, according to Justice Jackson's decision in the Steele seizure case, presidential power is at its lowest ebb. Third, like the mythical phoenix, DACA and DAPA rose from the ashes of congressional defeat. The President instituted these policies after Congress voted down the legislation he wanted. Further, the President repeated over and over and over again that he could not act unilaterally in the precise manner he did. His actions and statements create the prima facie case of bad faith and point towards a violation of the Take Care Clause. Third and finally, while I support comprehensive immigration reform, the President's unconstitutional actions cannot be sanctioned. I hasten to add, if upheld, Democrats have much, much more to fear from this dangerous precedent. Generally, Democrats like when the government takes more action, and Republicans like when the government takes less action. Today, Democrats may approve of the President's decision to halt deportations, delay unpopular provisions of Obamacare, or not prosecute marijuana crimes. However, the situation would be very, very different if a Republican president declined to enforce provisions of the tax code, waive mandates under environmental laws, or declined to implement Obamacare altogether. In the words of James Madison, Federalist Number 51, the only way to keep the separation of powers in place is for ambition to counteract ambition. Although the courts play an essential role to serve as the bulwarks of a limited Constitution, our republic cannot leave the all-important task of safeguarding freedom to the judiciary. To eliminate the dangers of non-enforcement, the Congress must counteract the President's ambition. The failure to do so here will continue the one-way ratchet towards executive supremacy and the dilution of the powers of the Congress and the sovereignty of the people. The rule of law and the Constitution itself are destined to fail if the separation of powers turn to mere parchment barriers that can be disregarded when the President deems a law broken. Thank you very much, and I welcome your questions.
Thank you, Professor Blackman. Professor Foley, welcome.
Yep. Chairman Goodlatte, Ranking Member Conyers, members of the committee, thank you for the opportunity to testify again today. My criticisms with the President's immigration actions are based on legal process and not any particular policy or political results. What shape immigration reform may ultimately take is not my concern as a constitutional scholar. My sole concern is with preserving the Constitution and its separation of powers architecture. President Obama has repeatedly said that his motivation for taking executive action on immigration is because he wants to fix our broken immigration system. And what this means is that he's trying to fix our immigration law, because, of course, immigration law is the only immigration system that we have. So he thinks our immigration law is broken, and he believes that it's broken because it fails to exempt certain categories that he thinks deserve exemption from deportation, and to whom he believes the law should grant benefits, such as work permits. But fixing a law by unilaterally changing it, by granting exemptions, remedies, and benefits that the law doesn't provide, is legislating, or to be more precise, it's amending. And that's a power that is given exclusively to Congress by the Constitution. The President's duty under the Constitution is not to fix a law that he thinks is broken, but to faithfully execute that law. When a president takes upon himself the power to change a law he doesn't like, we have no democracy anymore. We have instead a legislature of one. If Congress doesn't oppose President Obama's executive orders on immigration, it will be writing its own institutional obituary. When Congress fails to express disagreement with executive action, the courts tend to construe that as acquiescence or implied authorization by Congress. This is so-called Category 1 from Justice Jackson's concurrence in the Youngstown steel seizure case. So Congress needs to be very careful here. It has a constitutional responsibility to vigorously protect its turf. President Obama's immigration actions are unconstitutional for three separate and distinct reasons that I elaborate in the written statement. First, they alter the status of certain illegal immigrants, magically transforming them from deportable to not deportable. Second, they provide a remedy called deferred action that Congress has not explicitly or implicitly authorized for this category of people. Third, they confer benefits upon certain illegal immigrants that, again, Congress has not explicitly or implicitly approved for this population. While any one of these particular reasons will render executive action unconstitutional, when you have all three of them existing, as you do here with President Obama's executive actions on immigration, it creates sort of a Bermuda Triangle of unconstitutionality. It has a uniquely powerful gravitational pull that's capable of eviscerating Article 1's legislative powers. It's the combination of all three of these aspects of President Obama's executive orders on immigration that make it uniquely dangerous to this institution. I'd like to highlight 2 points that I elaborate on in the written statement that I think bear a little special mention. First, by granting work permits to DACA and DAPA recipients, President Obama's immigration orders encourage employers to hire illegal immigrants over lawful residents. And that's because the Affordable Care Act does not allow illegal immigrants to obtain tax credits when they buy qualifying health insurance. So what happens is if you hire more DACA and DAPA recipients, this lessens the employer's exposure to what's called the employer responsibility tax under the ACA. So the more illegal immigrants you hire who are eligible for DACA and DAPA, then the fewer who are eligible to buy health insurance, and the fewer who are going to obtain a tax credit for doing so, and therefore the fewer employees that you have in your workplace who are capable of triggering that employer responsibility tax. Now, why do I go into that detail? Because it means one important thing. President Obama's immigration actions undermine the ACA itself by undermining its goal of providing insurance via the workplace. So it's no small irony here that by granting work permits to DACA and DAPA recipients, President Obama is in fact undermining his own signature legislative achievement. Second, DACA and DAPA recipients are eligible to apply for something called advance parole. And that means they can get advance permission to leave the country and come back relatively quickly. Without advance parole, if you enter this country illegally and you leave, you have to then stay out for a long period of time, usually about 3 to 10 years, before you're allowed to re-enter. So once a DACA or DAPA recipient re-enters this country after being advanced paroled, they're considered to be paroled back into the country, and paroled individuals under the statute are eligible to adjust their legal status. And they can do this as long as they qualify for a visa, such as, let's say, an employer-sponsored visa. So what does this mean? It means that at least for some DAPA and DACA recipients, obtaining advance parole will provide a
Professor
pathway.
Foley, you've exceeded your time limit considerably as well. Could you please summarize?
Absolutely. It means that they will be able to have a pathway to U.S. citizenship. This is problematic because Congress has the sole power to decide who's granted citizenship under the Constitution. And even if just one person under DACA and DAPA is granted advance parole and applying subsequently for adjustment of status, what we have is a fundamental usurpation of Congress's power over naturalization. Thank you, and I look forward to your questions.
Thank you, Professor. Professor Legomsky, welcome.
Okay. Thank you very much, Mr. Chairman, Ranking Member Conyers, and honorable members of this committee for the privilege of testifying at this important hearing. I appreciate that reasonable minds can and do differ about the policy decisions, but I want to respectfully share my opinion that the President's actions are clearly within his legal authority. That's not just my opinion, by the way. This past November, 135 immigration law professors and scholars joined in a letter expressing their views that these actions are, quote, well within the legal authority of the executive branch, unquote. We are people who have spent years, and in some cases, including mine, decades, studying, teaching, researching, and writing on immigration law, and we are very familiar with what the statute allows and what it forbids. The President has not just one, but multiple sources of legal authority for these actions, and I've submitted a detailed written statement that documents each of them. I also identify there every legal objection I could think of that the President's critics have offered, and I've explained why, in my view, none of them ultimately withstand scrutiny. So with limited time, I'll hit just a few key points and refer you, please, to the written statement. Deferred action has been standard agency practice for many decades, and it's been expressly recognized by Congress in several provisions and in many court decisions. Furthermore, every lawyer knows that statutes are not the only source of law. The most explicit legal authority for deferred action, but not the only authority, is in the formal agency regulations, which have authorized it since the earliest days of the Reagan administration. These regulations, by the way, were adopted through notice and comment procedures, and they do have the force of law. None of these laws, not one of them, says or even remotely implies that deferred action is per se illegal whenever the number of recipients is large. The most vocal critics, including Judge Hainan in Brownsville, have misunderstood what deferred action is. They've confused deferred action itself with certain things that you can apply for if you get deferred action. But deferred action itself is just one form of prosecutorial discretion. It's a decision not to prioritize a person for removal, at least for the moment, and the only thing affirmative about it is that the agency is giving the person a piece of paper letting them know that that is the case. Every immigration scholar and practitioner knows that deferred action can be revoked at any time for any reason, and the government can bring removal proceedings at any time. Contrary to what my new friend Professor Foley has said, there is nothing in any law that says that this makes a person who is deportable not deportable or that it gives them some kind of status. That's simply not true. It's also true that existing laws allow deferred action recipients to apply for certain other things, including work permits and, if they're granted, Social Security cards. But the executive actions don't touch any of those laws. So my feeling is if you object to them, then by all means argue for challenging them. But there's nothing wrong with deferred action itself or this particular use of it. Importantly also, DACA and DAPA applications do not create binding rules.
Mr. Chairman, can we ask the witness to speak into the microphone, please?
I'm sorry.
Pull it a little closer to you there.
Thank you.
Sure. DACA and DAPA applications do not create binding rules or create substantive rights or statuses. The Secretary's memo says this explicitly. They are discretionary, both on paper and in actual practice. And as to the latter, I hope there's a chance to expand on that subject during the question period. And finally, there have been some melodramatic claims that if these executive actions are legal, then why, there must not be any limits at all to what future presidents can do. My written statements identify at least 4 significant, concrete, realistic limits. I have time now just to whiz through them, but in a nutshell, 1, the President cannot simply refuse to spend the resources Congress has appropriated for enforcement, as President Nixon famously discovered. But that's not a problem here because President Obama has spent every penny Congress has given him for immigration enforcement, and he's used it to remove 2 million people. Nothing in these executive actions will prevent him from continuing to do the same. 2, the government to remove 2 million people. Nothing in these executive actions will prevent him from continuing to do the same. 2, the governing statutes impose limits. They will generally indicate how broad the executive discretion is in a particular area. In this case, Congress has given the Secretary of Homeland Security especially broad responsibility for, and I quote, establishing national immigration enforcement policies and priorities. unquote. Now, nobody claims that power is limitless. It is, of course, subject to any specific statutory constraints, but to date, none of the critics have identified any specific statutory provisions that they can credibly say DACA or DAPA violate. 3, the particular priorities can't be arbitrary or capricious. These particular executive actions set 3 priorities: national security, public safety, and border security. I doubt many would say those are irrational. And 4th and finally, even if the priorities are rational, they can't conflict with any enforcement priorities that Congress has specifically mandated. But here, it's just the opposite. Congress has expressly mandated exactly these very same 3 priorities. So there are serious limits, and these actions fully respect them. Thank you very much again for the opportunity to testify.